Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Oxford University Press. I think it's an important book for consumer law and a general book for readers who want to know a little bit more information about where they stand concerning disputes they have with consumer products. The book is called The New Regulatory Framework for Consumer Dispute Resolution. A bit of a long title. It's been edited by Pablo Cortes, and as I say, it comes from OUP. Now, Elizabeth wrote the main review, and we'd had a full discussion about the book to get some idea of what the contents were and our approach to it. So our review title is Consumer Dispute Resolution. Should it be mandatory? Consider this range of current thinking as Britain leaves the European Union. And of course, as is the case with many of the issues we have today, Brexit looms large in these matters. Let's have a look at the book first. Here it is, black cover. There's the front, it's a hardback. There's the spine. There's not much on the back really at all. You can see that the book has been written in collaboration with or in association with the Nuffield Foundation. There's a dust cover, and that shows other books in the series by OUP, this particular series. And then at the front there's a blurb about the book itself. Starting at the back, the book runs to something approaching just under 500 pages. There is a short index, it's not very long, at the back. And there are, in fact, structures with the various chapter headings, and the structure is that you have the referencing periodicals and so forth, the bibliography at the back of each of the chapters. Now at the front there is the main front page there, which you can see, and you can then see all the detail about OUP, and then there's a dedication which I like to show for the purposes of the work. There's the acknowledgement section, and then you've also got the contents section. You can see it's split into various parts, 3 parts in total. The European Framework for Consumer Dispute Resolution, so that's the EU element. Consumer Dispute Resolution in selected member states, and then new trends in consumer dispute resolution. And clearly that's going to be a big issue as we move ahead with the withdrawal from the EU by Britain. This is the detailed content section. You can see a lot of information there. The actual individual, the short content section gives you the names of the individual contributors, which you can see there, a substantial amount. And the bibliography, there's a conclusion and bibliography at the end of each of the main chapters. Tables of cases, and then the list of. You've also got, in addition to the tables of cases, some legislation, again by country, and then after that you can see the various countries listed, directives and so forth. Then of course you've got the full list of contributors, and you can see a large number of people are listed there as people who have been part of the book. Now what you do have, you can see the chapter headings. You can see there's a short index at the beginning of each chapter. That's the introduction, which is very helpful. There are, of course, lots of copious footnotes, and you've got paragraph numbering, as you can see there. The paragraph numbering is not in quite the same way. You can see it's more to do with the subheads than anything else. And as you go through the book, you'll find that most of them do it in that particular way. So subheadings and numbering and lettering for various points that are being made. It's an excellent book in its own way. It is, of course, one that will probably need to be edited at some stage because of what's happened in the United Kingdom with the application to leave the EU. So what do we say about the book? Well, this. Despite the United Kingdom's decision to leave the European Union, Professor Pablo Cortes, who edits this formidable compilation of current research on EU-based consumer dispute resolution, is as optimistic as might be hoped for given the current climate of uncertainty as to whether Brexit will be hard won or a soft touch. This is what he says. Either way, he says, I would not anticipate sudden change in the field of consumer redress. And I think he's right on that. This is going to be a long process. And of course, I will say on behalf of a lot of people, certainly within the legal profession, that there are some very good laws that we want to keep, which emanated from Europe, and that will be part and parcel of the Great Repeal Act itself and the aftermath. Now, this book is based on a range of research papers presented at a recent conference at the University of Leicester. And the book, as I said, comes from Oxford University Press, focusing on the impact and implications of new European Union legislation on consumer dispute resolution. Now, dispute resolution, as we know, is a very popular mechanism to adjudicate differences between parties. But it does have a very important role to play both here and abroad. The legal framework and the main methods of dispute resolution are examined in detail, including arbitration, mediation and ombudsman services, following the recently implemented directive and regulation on respectively the following. That's alternative dispute resolution, or ADR, online dispute resolution, ODR, and resolving disputes via a pan-European ODR platform sounds like a good thing, at least in some circumstances. And I have to say that I think quite a few disputes will be resolved this way in the future, although there will always be a large number of cases where you have to deal specifically with live witnesses in a courtroom setting. I don't see any way around that particular problem where the parties are so dug in. It's as simple as that, really. But there are quite strong suggestions that there can be a bit of an expansion with dispute resolution in certain areas. Basically, the editor's view is that mediation of whatever kind should eventually evolve so that it becomes compulsory as part of the court process. But should it? Now, that's a big question, because I've found that some jurisdictions, some court systems, they have effectively an automatic mediation. So the answer, as you would expect, is that there is no one answer, because some courts do, some court areas do, some court areas don't. The thing is, if you can encourage mediation and encourage the parties to talk to each other, that helps. I have quite a few problems where the parties just will not talk to each other at all, and there is a complete and utter lack of agreement. Sometimes very bad behaviour by some barristers as well. I have to say that, because some of them do not seem to have understood that we are meant to talk to each other prior to going to court. It does save a lot of time and acrimony. Anyway, that's another day. Opinions and practices, of course, are going to vary across the European Union and the non-European Union jurisdictions for the future about the way in which we deal with whether these sorts of dispute resolutions are compulsory or not. And so watch this space. An example is given, of course, from Italy, where apparently it can take an average of 8 years for a civil case to reach the Italian Supreme Court. Disgraceful, if you think about it, compared with approximately 1 year elsewhere. It's this sort of problem that has brought the continent into a certain amount of disrepute. And it really is time that some of these countries, instead of criticising Britain, actually got their own acts together. And that is actually covering quite a large number of countries who should and would be quite capable of speeding things up if they just bothered to do a little bit of work. That's actually the bottom line on a lot of this, but they don't like the hard truth. That's the difficulty. Now, for instance, mediation has been used, of course, to drive cases through the legal system. And certain changes introduced by recent legislation have enabled greater involvement by lawyers, which, amongst other things, has meant greater acceptance of mediation by the legal profession. As I've said, there are pluses and minuses for mediation. It is meant to be independent. A lot of people aren't convinced. I'm not particularly convinced about some aspects of it, because the people I deal with do not want to mediate, and that means something is going to be imposed on them. It's also interesting, of course, in the book to learn that mandatory mediation has become firmly established in the province of Ontario, Canada, where, as it is applied to the majority of civil cases, it has become difficult for litigants to opt out without judicial sanction. Again, that's probably going a bit too far, but at the same time, It does, of course, speed things up, and it will save money at the end of the day, because quite often it will resolve. The issue will revolve about who you believe as to what actually happened. And by comparison then with the what could be described as the extreme view in Ontario, the approach to mediation in England and Wales is predictably pragmatic. You might conclude then that the mediation we have is encouraged in certain cases but not robustly, and rarely if ever is it compulsory. And again, as I say, that is generally where we are at the moment, but we could have quite a substantial sea change with the online courts. The much more complicated realities are examined in this book, which brings together the research and considered opinions of over 20 contributors. As I say, listed, I can't name them all, but thank you to them. They provide comparative views of consumer ADR across 9 EU countries, plus, and there's an additional chapter on consumer redress in the United States, which I found very helpful. As the UK then faces a somewhat uncertain future, I nearly said certain, uncertain future following Brexit, whether it's a hard or soft one is immaterial, we're leaving. The final part of this book should be of particular interest. It seeks to identify best practice in alternative dispute resolution and speculates on future trends. Now, Cortes from the University of Leicester School of Law concludes by advocating, quote, the mandatory participation of traders in CDR. As the UK departs from the EU, this point may not be reached any time soon. That's certainly our view, and I think that of a lot of other practitioners. Nonetheless, arbitrators, mediators, and yes, lawyers will find this book not only an absorbing and enlightening read, but a useful and certainly voluminous source of references for future research, and the publication date is cited at 2016. So it's actually coincided with the decision to go. There's the book again, just opening it in the middle. It's a heavy book. You see, there are some tables. Again, this has been very thoroughly researched, as to be expected. It's very much the standard house style for the Oxford University Press. This is consumer ADR directives in Ireland. Now, I will say one thing, which is again not in the review, but Ireland has always taken a bit of a lead actually on mediation and ADR, and so it's quite interesting to watch how they go about their business. You can see the structure of the book. Then there's not very much by way of page paragraph numbering, and actually there's a very small use of footnotes, which I think I'm really rather relieved to see. I'd like to thank Pablo Cortes anyway, and all the people involved in this book. It's a very worthy contribution at a time of massive change for us here and on the continent. And it's quite possible that this book will come into a new edition in due course as we see the full implications of Britain's sad decision to withdraw from the European Union. Thank you to all. And once again, thank you very much to OUP. You make our lives a lot easier by producing these books, so many thanks. Bye-bye.